exactly what do you think is going to happen in the sentencing hearing? Will Luigi testify? Would he get up on the stand where he could go through feelings that he had leading up to shooting and killing Brian Thompson? Would a judge allow for that kind of testimony? Luigi Mangione could be a free man by the time he's 48 years old, and maybe sooner, Mark. This was a remarkable stroke of brilliance on the part of the defense to plead guilty to this. It's not over yet, but you and I have been talking about this, and there is not going to be a trial of Luigi Mangione, but there is going to be a trial. There's going to be a trial in December about the healthcare system in the United States. And that is the most ironic thing here, that Luigi Mangione, in trying to get a lighter sentence, certainly the prosecution wants life, but in terms of trying to get, either what the median sentence would be, the range being 24 years to 30, they want less than that. But in trying to do so, they are going to put the healthcare system on trial, and Karen Agnifilo made that clear today.
Not only did she make it clear, did you notice the one thing that, as far as I can tell, was not reported on before today, which is Friday, was the fact that Luigi allocated to, on his factual basis, the fact that there was an email that was sent to the investor conference. And that is how, you might want to talk about that for a second, because that is stunning, frankly, in terms of what you're talking about.
Well, what he said was, it's really interesting. Let's do that. But before we get to it, I mean, the weird thing about this case is this, that Luigi, what he said in court was, I broke my back. And ever since then, I've been in agony. I've been in pain. It's ruined my life. And he started to complain about the healthcare system, but we did a lot of digging here at TMZ on Luigi's case. We did a documentary on it. We did a lot of digging. We talked to a lot of his friends, and he wasn't really complaining personally about the healthcare system. He was complaining about corporate greed generally, not healthcare, but corporate greed. They're now trying to turn this, and maybe they've got some evidence behind it, but they're trying to turn this into a grievance with healthcare. And I know that Luigi, for example, he bought 200 copies of a book that a guy had written on corporate greed. And the guy lived in Indonesia. Luigi, I think, flew to Indonesia, met with the guy, gave him notes on how he could change the book and make it better, bought all these books to get it on the bestseller list. So he was obsessed, but he was obsessed generally with corporate greed. And, and maybe Brian Thompson was a symbol of that for Luigi, but now it sounds like they're trying to argue it's not corporate greed, it's specifically the healthcare system screwed him over.
Well, and that fits in with what I was saying about the email on the investor conference. I mean, the luring out, so to speak, or the finding or the tracking, frankly, what he pled to, which was the internet stalking, so to speak. He had sent an email. And if you believe what I think is going to unfold here, that email was, he got an almost immediate response to that email in terms of the details of the so-called investor conference.
Yeah, and I saw this two ways. One is he sent the email saying they were interested in investing, in United Healthcare or whatever it was, to find out where Brian Thompson was going to be. But the other part of it was that a lot of people never get an answer from an insurance company, and the insurance company never calls back. And he's saying, boy, when it comes to us wanting to invest money in a healthcare company, they call us back like that. So in a way, I thought that the defense was going to turn that into, you see, that it's all about corporate greed. So I think...
Oh, that's exactly why that's why it's revelatory in terms of where you see this thing headed. To your point, and for those who say, well, what about the state case? As he entered the plea, the firm had someone bicycling down the street to file the motion to prevent the state case from going to trial next month.
And let's talk about that. But before we do, I December is going to be so interesting when they have a sentencing hearing, because presumably they're going to be able to call witnesses if they want, I would think. I mean, I don't think this is all going to be just based on briefs. But, the feds do not allow the defense of extreme emotional disturbance. That's something that he would have argued.
In the guilt phase, you're going to get virtually the same kind of evidence in a sentencing.
It's exactly the same thing. So what happened was he was going to plead that to mitigate what he did in the state case, but then realized if he did that and the state case came before the federal case, he'd be screwed in the federal case because he's admitting guilt and they can't use the defense. By pleading guilty, if the state case goes away, he's got that very defense for sentencing, which is the absolute best thing he could possibly have. Now, I don't know how the judge is going to receive it, but they're going to argue that he was so angry about corporate greed / healthcare that his mind was distorted. And yeah, he knew it was wrong. He knew it was illegal. He killed the guy. But still, and again, I'm not embracing this. I'm just saying this is the argument. But still, he felt this was in some way a noble cause because he was so overwrought with the damage that the healthcare system was doing. That's going to be the essence of his defense. And, I would guess that maybe he's going to try to present some evidence of that to the judge to say, look, I'm not the only, in fact, Karen Agnifilo even said it. He's not the only one that suffered this way. So what they're going to try to play on the judge and say, look, this has been a rampant problem in America. People's lives are ruined. People are dying because of this. So how do you not look at the fact that he was just, embracing a sentiment of anger that people in the public have been feeling for years? I mean, I think that's the argument.
I have no doubt that that's the argument. For a sentencing, we will see a robust sentencing memo. It'll be written by Karen, or there's another guy who works with her who's in the pictures all the time. Forget his name, but
Mark Agnifilo, her husband.
No, not Mark. There's another guy. Mark I know very well, but there's another guy. I forget his name. I think it's the same as my kid, but I'm not sure. But that sentencing memo, to your point, will detail. It would not surprise me in the least if you'll have a very detailed psychological examination, sociological kind of history, do a robust detail of everything that happened. Two other things that I thought were interesting today, besides the email. I thought that email was fascinating, the email about the investor conference. I thought also Brian Thompson's family was there, and they issued a statement. And when you saw that statement, it looked like they were kind of supportive of this. In a sense,
I disagree.
I put it up. I supportive. I read it. Look, I have seen family members. Look, you don't have to look any farther than Idaho and that young man, because the victims' families were irate that he was allowed to plead. This was not the same.
It wasn't irate, but they want life for him. They want life.
I understand that, but they understand going into this. The Brian Thompson's family, they understand that this potentially is going to cut off a state court trial. Now, and we talked about the letter that was under seal from July 2nd from the DA's office, who's irate about this. If you read the letter, that was over a month ago. But I give you another thing that we haven't talked about. There still is a determination that is going to have to be made by the state court judge. He's going to have to say, okay, I'm now interpreting the law. I'm now interpreting the double jeopardy statute, because it's a New York State statute, as covering this once in jeopardy. Interestingly, you remember who the last person famously who was successful
Paul
in the New
Manafort.
Paul Manafort, represented by?
I know this.
Yeah. Monday of this week, he was confirmed as the Attorney
Oh,
General.
right. He was represented by Todd Blanche.
Todd Blanche. Guess who the prosecutor's assistant, Cy Vance's assistant, was?
Who?
Karen Agnifilo.
Ah, how interesting. So, look,
Now,
before we
you
get
know
into
what they
double
may
jeopardy, I
do,
want to
though?
ask you something because I think everybody wants to know this. Exactly what do you think is going to happen in the sentencing hearing? Is the judge going to do this all based on briefs and reports? Is the judge going to allow testimony? Will Luigi testify? Would he get up on the stand? I mean, would the judge allow this where he could go through the, feelings that he had leading up to shooting and killing Brian Thompson? Would a judge allow for that kind of testimony?
A defendant has a right to what's called allocute, which means state your position prior to say that is a right that is enshrined in the criminal
Which he
justice
can
system.
do, but could the defense call witnesses?
Yes, and I think they will. I think you will. I think you will see not only the defense. I think you're going to see the government. I think the
Oh, yeah.
government are going to call. I think you're going to see what are called victim impact statements.
So this is going to feel like a trial in a way, with the predicate he killed Brian Thompson, but now the issue, was there anything to mitigate this? And it goes right to putting healthcare on trial.
That is when you say predicate, I guess I'll take that and say the extreme emotional disturbance that caused us to be in this place. And this judge is the only prism through which you have to look and understand what happened here. Then you've got, he's not going to get anywhere unless he expresses incredible remorse and contrition, because who's going to say, oh, it's okay, and go quietly into the federal prison?
Well, that's interesting. Does he say, what I now looking back, what I did is monstrous. I can't believe I did it. But at the time, I was feeling, askew or somehow. Does he acknowledge it's monstrous now, or not? Or does he kind of toe the line?
Well, the knee-jerk or reflexive defense lawyer reaction would be that, yes, you have to be contrite, you have to be remorseful. Whether he does that might change day to day or hour to hour.
Because he said, I knew it was illegal. He said that in court. So, look, judges, I think I've told you this before. There was when I was in law school a long time ago, and I was reading cases, there was a Supreme Court justice named McReynolds. He may have been the dumbest Supreme Court justice ever to sit there on the high court. But he said something in a case that I read, and I have never forgotten it. And I'm going to say it now. I can't believe I still remember it. He said, an amorphous dummy, unspotted by human emotion, is an unbecoming receptacle for judicial power. And what that means is that you don't want a judge who is devoid of emotion, who doesn't understand the real world, humanity, because that person is not really fit to decide cases. You have to understand people and emotions to decide cases. And that kind of brings me to Luigi, that you have a judge who's very well respected. She was a former SDNY U.S. attorney, and everybody respects her. She can't ignore what's gone on, what the backdrop is with Luigi Mangione, with the support that he had in the public, with the show of force, with the perp walk, and everything associated with it. So does this judge, because the judge is going to say that I'm basing everything on the merits of the case when I sentence, but you can't ignore that. I mean, you can't unsee it.
That's going to cut both ways, because trust me, the government is going to make a full-throated argument that you can't sentence the judge, you cannot downward depart. The whole thing is going to be there are sentencing guidelines. When you said could be out by, would you say 48, 47, or 48? That's if he gets sentenced to within the guideline range. Government is clearly going to argue.
The government already said they're asking for life.
Yeah, they're asking for what's called an upward departure. Part of their argument will be, I can preview it right now, they're going to say, Judge, you cannot only not sentence within the guidelines, you have to understand what happened here. They used the dueling sovereignty, meaning the federal and the state concurrent prosecutions, to game the system so that he ended up not getting prosecuted for murder. And therefore, he's got a constituency, and you have to send a message to this constituency that you can't reward for this kind of gamesmanship, and you have to upward depart.
Pleading guilty is not gamesmanship, it's a right.
Yeah, it is a right, and they're going to say the government, mark my words, is going to argue that he already got a benefit by pleading guilty, and the benefit has already been articulated by the July 2nd under seal letter. That is going to be, in fact, it would not surprise me, Harvey, I'll ask you this. I don't think that Alvin Bragg or the Manhattan DA's office is going to go quietly into the night. I think that they are so pissed.
Well, they've already said they're going to fight it.
Yeah, not only fight it, I think that if they lose the fight, meaning the judge says once in jeopardy, what I could see a prosecutor, would not surprise me in the least, saying, "Oh, we're going to prosecute on the gun charge."
That's it. I never thought of that. That's really interesting. I never thought of that.
There's
yeah, but it would be a concurrent sentence still, right?
No, would not be. Would not be. In fact, you could make an argument that he could get sentenced. They could bring that charge and arguably wait post-sentencing and then do a writ ad prosequendum, which is what the feds did to get him into custody, bring him back to the state court, hold the body there, and then have all kinds of shenanigans. And I guarantee you, 1,000%, they've talked about that in the Manhattan DA's office.
So when you talk about what the prosecution is going to argue in the sentencing hearing, what you're really saying is if you don't throw the book at him, you are not deterring other people from doing what Luigi Mangione did to other CEOs.
Correct, because remember, the criminal justice system, you've got various theories of crime and punishment. And crime and punishment, it revolves around, at its base level, one is deterrence. I mean, my father always used to say when somebody would argue, you've got to send a message, he'd say, use Western Union, but nobody even knows what that means anymore. So, but judges understand that they use it all the time, every day in every court in the country. They need to speak to the community. The government is going to wrap themselves up in this idea that not only is this a message and for the family, it's Brian Thompson's family himself, but it's also, you've got to send a message to the community, especially in a case like this, where there's going to be all kinds of people arguing that that he should have been absolved of any punishment for this case because he was doing the Lord's work. There are people who argue that. If you read your comments every time we talk about this case, there are legions of people who make the argument that he should get a pass.
So I want to get back to the gun charge thing. If they were to do that, I don't understand why that wouldn't be a concurrent sentence with whatever he gets federally. I don't understand why it wouldn't just kind of fold into that.
Well, there is an argument for that, but there also is a very strong argument that if your body is in the custody of the other sovereign and you've already been sentenced, that the last judge is kind of ollie oxen free. He gets to control what the subsequent sentence is. There's nothing that would compel him necessarily to have to give a concurrent sentence.
Okay, so let's talk about this double jeopardy thing. So it's the same set of facts. I mean, aside from the gun issue, same set of facts. You know, he killed Brian Thompson. He shot and killed Brian Thompson. And in a way, I think the fact that Luigi said all that in court today was to set up the double jeopardy argument. I think he said, I mean, he didn't have to say to the judge, I shot and I killed Brian Thompson and I knew it was wrong. He didn't have to say any of that, but he could have simply said guilty. But I think he was.
No, that's where I disagree. In federal court, you have to, especially in that district, they don't allow what are called Alford pleas, which are in California. If you're a California practitioner, you'll know it's called the People versus West. They want a factual basis. I've had cases in that district where it took me not one, not two, but 3 times to get my client, the accused, to articulate a factual basis that the judge would accept. You have to have a factual basis. In fact, I think all this week there was a lot of back and forth about the factual basis. I was on the record saying that earlier this week. And yes, you're absolutely right that what he said was to create a factual basis on the record so that when the judge does the factual analysis in the state court,
Right.
that he can say, hey, this is the same set of facts under the New York state law, and therefore I'm ruling that they are the same and that he's been once in jeopardy and that you cannot prosecute again. And I'll give you one more example. Years ago, when Alan Jackson of Karen Reed fame was a a relatively new deputy DA, we had a murder case in LA. Was a Japanese businessman who came to LA with his wife. His wife was murdered. He then went to Japan. He was tried in Japan for the murder case. He was acquitted in Japan, yet there was still a warrant out in California. He stepped foot in Guam and he was taken into custody. I made the argument defending him that he was once in jeopardy and that they could not extradite him. The judge said, Mr. Geragos, you're right, because we had back then in California, similar statute, once in jeopardy, on the California side. Alan Jackson, this is when I knew Alan had game. He came up with, well, I'm not charging, we're going to add a count, we're going to add a conspiracy to commit murder. And the judge said, I got to get the body here in order to do the factual determination. And that is, I think, the narrow pathway that the Manhattan DA has probably been exploring for the last 6 weeks on what to do in response to the plea.
Okay, before we go further on that, what happened to the Japanese businessman?
He was here for one day. I was in Europe, and I sent down one of my associates to see him in custody, and he ended up dead by the next day. And
what?
In LAPD custody.
How?
Supposedly hung himself.
Oh my God! I did not see that. Wow.
Yeah.
Okay. Okay. Sorry. Okay. Back to this. So there's no conspiracy here because he did it alone. So because I've looked at this law in New York, and I got to say, it is definitely the same set of facts. I mean, they're not, there's nothing different between what the feds are really alleging and what the state is alleging. It's the same set of facts. So it seems to me the defense has an advantage here.
Well, the defense clearly has an advantage, which is why, and maybe Branson post-production will show the letter on the screen. This letter, July 2nd, was filed under seal by the Manhattan DA's office. They obviously knew this train was coming down the tracks,
right?
And they've been worried about it ever since, because they knew once the judge in the previous iteration of this double jeopardy motion said, denied without prejudice, it's premature. All that tells you is premature, meaning what? What has to happen? There has to be a plea or an acquittal. There's now been a plea.
So this nobody's going to just walk away however the judge rules. This is going to get appealed. I could see this case ending up at the U.S. Supreme Court on deciding on the constitutional right against double jeopardy. I could see this ending up at the Supreme Court. With the composition of the court, how would they rule?
Same way they did with Rodney King. The issue's been raised in reverse. they can do in reverse. And if you read that opinion, doesn't I don't think you would see a tremendous change depending on the composition of the court. One of the things, though, that it would not surprise me that the Manhattan prosecutors will argue is they will say, Judge, our case is set for trial next month in September, and he has not been sentenced yet in federal court. Therefore, the conviction is not final. If the conviction is not final, there is no double jeopardy. Let's pick 12 and try our case first.
I want to go back to Luigi for a minute. Luigi came from a very wealthy family, and he chose to kind of break off from that and did kind of lead a more austere life than the lives of his family. Nevertheless, he came from privilege. Is that going to hurt him? Because in terms of suffering through the healthcare system, I remember talking to one of his our roommate of his in Hawaii when he lived there, who was talking about his back pain and how he had been complaining about back pain, and it was something that was dogging him. But it wasn't so much complaining that I can't get medical help. He did have a safety net. He did have means. So does that diminish the argument that he was so overwrought? Because ultimately, Luigi had ways of getting help.
Well, it certainly hasn't dampened the interest, support, and or resonance that has happened in the community with him. I think, and I always said prior to today, that jury selection was going to be one of those unique times that was more trouble for the prosecution than the defense. I'm always worried as a defense lawyer about stealth jurors. This was one of the unique outlier situations where that had to trouble the prosecutors. They have to walk in the shoes of most defense lawyers who defend notorious people who are always worried somebody's going to lie with an agenda to get on to try to convict. This is quite the opposite. I'd be very leery if I were a prosecutor in a hypothetical jury selection as to whether or not I was picking somebody under the age of 35 in this case.
Yeah, but I'm not talking about juries. I'm talking about prosecutors saying to the judge, look, this guy is, a wolf in sheep's clothing. He's talking about, his upset over health care and that his broken back ruined his life and all of this. His family had money, and he had access to that if he wanted. And sure, he may have seen what other people are going through, but to look at him and say, this is what he was going through by necessity, it was more by choice in the sense, if he didn't want to go to his family and ask for help, that was his choice. But he knew they were there, and he chose not to go to them at various points, especially leading up to the murder or the killing. And so, he seems less sympathetic in that sense to a judge who is deciding whether there are mitigating factors here.
Well, you're absolutely right, and let me layer over that. The usual defendant or accused in the criminal justice system, even federally, but especially in state court, if you were to sit in the state court, either in Manhattan, LA, anywhere, it's disproportionate, the indigent. And it's disproportionate people who don't have the advantages that he had. And if you don't think, having defended my share of people of means, if you don't think that that goes into the calculation, I've heard it once, I've heard it 1,000 times with the judge saying you had every advantage of the world as opposed to most of the people that I see in front of me day in, day out. Yes, absolutely, you're right.
Okay, my final question. So Karen Agnifilo is an amazing lawyer. But so is Mark Agnifilo, her husband, who pulled off an unbelievable win in the Diddy case. And again, I know he's in prison. That was a win. He never would have been prosecuted for these offenses. What they wanted to get him on, he was acquitted. And nobody thought Mark Agnifilo could pull that off. So you got these two unbelievably talented lawyers who know how to craft arguments and do what seemed like the impossible going into the case in each situation. So my question is this. When they're at the dinner table and they are arguing about something, who wins?
Oh, 100 times out of 100, Karen.
Why?
Just that's the way it is. Remember, like when Karen left the office, she came to work for me. I don't think Karen wins 100 times out of 100. It's not even a question.
I didn't know that. Karen came to your firm?
Yeah, she came straight from Cy Vance to me.
I did not know that.
And now my firstborn is
working for her.
Yeah. Exactly.
Oh my God. Okay, well, Mark will be thrilled to hear that.
Well, Mark, I think I speak for Mark, although I'm not allowed to talk to him. I guess today I come out of my timeout, but I think I speak for Mark when he says I've heard enough of their discussions with the two of them together to say that I have a pretty good informed opinion there.
Oh my God, that's amazing. Okay, I'll see you next week.
Okay, bye, Harvey.